Hi there, this is Jonathan Ginsberg, and I'm a Social Security Disability attorney. Today I'd like to answer a question that I got from one of my video viewers, and that is, why do I need to have a hearing if my claims file contains really compelling medical evidence? What's the reason that I have to actually go through the process of a hearing? Why can't they decide my case on the record without me having to appear? And there's really several answers to this. It's a good question. I think it's a legitimate question. I think first and foremost, the practical side of it is that until your hearing is actually scheduled in the judge's queue, no judge is going to really look at it. The judges in our country, for the most part, are overworked. They have lots and lots of cases to go through, and many times they don't really look at the file in any kind of detail until maybe a few days before the hearing. So there's a good chance that the judge simply doesn't have time to go through and figure out that, yes, your case should be approved on the record. One of the things that I try to do in my cases, whenever possible, is I will write a pre-hearing brief and request for on-the-record decision, and many times that does give the judge a heads up that, yes, this is the case that could be decided on the record and would avoid the necessity of a hearing. But again, that's up to the judge entirely. And that's really a second major point, is that every judge does his or her cases differently. Some judges like to see you, and they don't like to decide any cases on the record. They want to see you, and even despite what the medical record says, they want to get a sense of who you are. They want to listen to you, hear testimony. They want to give you your day in court, but they want to observe you personally. So again, if the judge takes that position, it doesn't really matter what you want as far as an on-the-record decision. The judge is going to insist on it. I think a third reason is that many medical records do not speak the language that Social Security needs to approve cases. And what I mean by that is that, remember, the issue in a disability case is, do you have a medical issue that impacts your capacity for work? And if you've watched my videos, you know that there are different ways to win a case. Meet a listing, meet a grid rule, or prove your functional capacity would eliminate pretty much every job. Well, medical records may not talk to those factors. So, for example, if your case is listing level, your medical records may not specifically address the particular listing. They may not have all the tests that are required by the listing, or it may be buried in 150, 200 pages of records where the judge really has to find it. And again, that's where an attorney comes into play. We would highlight that for the judge. Same with the grid rules. The grid rules are basically for people over 50 with a physical impairment that has typically have a high school or less education. Those pieces have to be put together. So, for example, when I'm doing an argument on the record for the grid rule, I'll make it very clear. This is my client's date of birth, his or her age. This is his or her education. This is the past work, and this is my estimate as to what the Dictionary of Occupational Titles code is, so that we can spell it out very clearly for the judge, make his or her life easier. And of course, in a functional capacity argument, there's a lot of different factors, and again, without looking through the file in detail, the judge is not going to be able to pick it up before the hearing is actually scheduled. Now, there are, in many district offices, many hearing offices rather, there are attorney advisors that help the judges prepare these cases for hearing, and again, the same sort of issue applies. They don't have a lot of time. It's got to be laid out very, very clearly for them, and unless the file is unusually well put together and the medical evidence is very, very clear, they're not going to necessarily spot it. They go in with the assumption that these cases are going to be scheduled for a hearing. So the answer to the question is that many cases that could be decided on the record are not, simply because of time and the workload of the judges and the attorney advisors that assist them. Other times it simply needs, the pieces need to be put together, which is, again, what a lawyer can do. And then there's some cases where the judge just wants to see you and there's nothing you can do about that at all. But that is the reason in many cases why we don't get on the record decisions, although again, if you do a pre-hearing brief, that does improve your odds. Hope you found this helpful. If you did, please give it a thumbs up on YouTube, like it on Facebook, and subscribe to our channels. Any questions, please reach out to me. And until next time, I wish you the best. Thanks a lot. Hi, this is Jonathan Ginsberg, and I hope you found this video helpful. If you'd like to know more about how to win your Social Security disability case, I'd like to invite you to download my Secrets to Getting Approved Early Survival Kit that I created just for people like you. Currently, I'm making the survival kit available at no cost, and I encourage you to grab your copy now. Some of the topics I cover include How do I know if I have a case? Is it the right time for me to file my claim? 9 common mistakes that can doom your case. The 3 must-have arguments you use to win your case. And a topic that every disability claimant wants to know, how to avoid trick questions from the judge. If you or a loved one need to win Social Security disability benefits, you'll find the Survival Kit essential reading. Download your Survival Kit right now and at no cost. Just visit ssdanswers.com/survival and sign up. It's that easy. Please act now. And as always, I wish you the best.